I now invite Honorable Justice Chandrachud, Chief Justice of India, to address us.
My very distinguished brother and Chief Justice of India designate Justice Ranji, my dear friends and brothers, Justice Narasimha and Justice Vishwanathan, Mr. Vipin Nair, the President of SCORA, Mr. Amit Sharma, Vice President, Mr. Nikhil Jain, the Honorary Secretary, Senior Counsel, who also sauntered into the SCORA function today, and of course all the members of the SCORA, the advocates on record, were so close to my heart, and members of the registry led by the able Secretary General. True enough, it is that on Monday, as someone said, the Ranji Trophy passes from Mumbai to Delhi. But I had a different take on this. In my childhood, now with IPL and T20, all the traditional tournaments are not so widely played. But in my childhood, the Ranji Trophy champions, which were usually Mumbai, would play against the rest of India in a tournament called the Irani Cup. So really speaking, both Brother Justice Sanjeev Khanna and I have been playing for the rest of India in the Irani Cup. My mother used to say when I was a young child, she had this ability, an uncanny ability to come up with some real pearls of wisdom. And I wondered where they suddenly descended from, both in English and in Marathi. And she had this little quotation which she would come up and say, and which says, when the heart is full, the tongue is tied, she would say. So really speaking today, I think my tongue is tied for a change for somebody who's as garrulous in the court. But when the heart is full, the tongue is tied. When the mind is full, as it is in the court, the tongue is never tied. Because the tongue follows the mind and it never stops talking. Of course, I was once told by a very distinguished judge of the Bombay High Court who came to the Supreme Court that, why judges talk, particularly in the post-lunch session, that is because generally you're feeling sleepy and you try and avert sleep by talking a lot. That rarely happened to me. But today I honestly don't know what to say in response to such a beautiful, beautiful speech which was made by Amit and by Vipin's very fond words, and likewise what Nikhil said. When I came to the Supreme Court in May 2016, I generally knew that advocates on record are people who file cases, and then you have the senior counsel who argue cases. We had a similar system in Mumbai of the solicitors and the counsel until the system of solicitors was abolished sometime around 1974. My late former wife was actually a member of the Advocates on Record Association, in the sense that anybody who qualified for the Bombay Incorporated Law Society Solicitors exam automatically could become an advocate on record enrolled here. The only two difficulties were that you had to, of course, buy a ticket to come and appear before the judge in chambers when you didn't have much work in the Supreme Court. And the second was that you had to give an address and you had to also find a clerk who would say that I'll file for you. But I do remember her coming here to appear before Justice Ramaswamy, Justice K. Ramaswamy, who was then the chamber judge at the time when she was applying for enrollment as an advocate on record. I really don't think she filed any matter, but she was still an advocate on record. So I have more than one reason why I have such a close association with this association. But soon after I was appointed as a judge of the Supreme Court, I quite realized that it's not just this formal division between senior counsel who don't file matters and the advocates on record who file matters. But really speaking, the whole institution of the advocates on record is so significant because it reflects two things. it reflects the diversity of India. It reflects professionals practicing before the Supreme Court who are truly in touch with clients, litigants all over the country. And in that sense, truly, professionals who are the pulse beat of what happens on the ground in our society. So many of you have appeared before me in the last 8.5 years, and I can almost I have a photographic memory, as my wife tells me. I can almost pick out the cases where you have appeared and you've conducted those cases with such a sense of commitment and drive. And I particularly enjoyed it when the seniors didn't appear. Because when the seniors appear in a case, you feel, with due respect, of course, to my distinguished brother, Justice Chandrachud. The good part about a senior appearing in a case is that you have a slightly greater degree of objectivity. The senior will not argue, or hopefully not argue things which should not be argued. But when you have a senior appearing in a case, the difference between an advocate on record appearing in a case and a senior appearing in a case is that the advocate on record always treats the case as their own baby. For the senior, after all, it's that one appearance for that evening, or one conference in the evening and one appearance the next morning in court. Not so with the advocate on record. You so often find that the advocate on record perhaps sometimes takes things a little too far because you're so committed to the case, even if a case doesn't have that good arguable point. And I always felt this, and I never felt throughout my career that the advocate on record was stretching their luck beyond the point or stretching the case beyond the point, because there's always this perception that there is a human face behind every case. And it is that commitment to the cause of the human face which really, in that sense, unites both the advocates on record and the judges. Very often I have been asked as to why I listened so long to a case. Now I can let out the secret, since I have only one more day, probably 45 cases, so you may not be able to use it too much to your advantage. 45 odd cases tomorrow. But one of the reasons why I listen so long to the advocates on record, and particularly in the juniors in the case, there are two reasons. One, I feel this is, after all, the court of last resort. Nothing really lies after the court says, all right, thank you, and dismiss. You, of course, get these bunches of review petitions and, curative petitions. Curative petitions are very often assessed, as I do, by who are giving the certificate. Some give certificates at random, some give them with greater deliberation. But one of the reasons why I thought, you must always hear the young counsel, particularly the advocates on record, is because this is the last point of recourse for the litigant. There is nothing hereafter that they can do. The second thing, and the second reason, which is perhaps more personal but more fundamental to me, is that I was always unsure, even after 8.5 years on the bench, on whether I had really grasped everything in the case. And the more you delve within your own heart and thoughts and mind, you're also conscious of your own limitations, both in terms of the acquisition of knowledge and in terms of the ability of the human mind to understand everything that there is in a relationship, whether it's a relationship between spouses, a relationship between partners, a relationship between corporates, a relationship between two levels of government. So you're always asking yourself that perhaps have I missed something? Would I have not missed something if I had heard that case for a little longer? But the one signal aspect of our bar which I find is the tremendous sense of faith which our advocates have, particularly the AORs have, in the institution of the judges of this court. So very often you find that a case comes up with very high stakes. I had one case like that yesterday. And I then suggested a compromise to both the sets of, there were three factions actually, and I suggested a compromise. And they virtually accepted that you dictate the compromise, and this would be acceptable to us. Now that's putting a very huge burden on the mind of the court, because while you suggest a compromise, you want parties to say no, because when they say no, then you can sort of negotiate with them and say that, well, all right, we'll try and work out something which you feel is appropriate. When lawyers say yes, then you feel that, my God, this is a huge burden which they have placed on me. So yesterday when I dictated the order in a very important commercial dispute, I said, I'm not going to sign the order. Take this order, sit with the court master in the court master's room. If you want any corrections, come today. If you find that you need an extra day, come tomorrow and tell me what the correction should be. So they came back today and said, well, you wanted some corrections in some paragraphs, which we have now agreed to. So this shows really the intense faith which advocates on record have in the institution of the Supreme Court. So it's mutual. Our relationship is mutual. We have that sense of faith in advocates on record because we believe you represent the voice of the litigants. And we presume that you're not just post offices for somebody else's brief. Likewise, you have that sense of faith in us because you know that we listen to you patiently, conscious of the fact that you represent the voice of that small little individual for whom you are representing the cause of justice. I'll just share with you that we delivered judgment yesterday in the Constitution bench, where the might of the insurance companies was pitted against individual claimants. And the issue before us was whether the holder of a license to drive a light motor vehicle can drive a transport vehicle with a laden weight less than 7,500 kilograms. After the insurance companies argued with the whole battery of lawyers, and then finally the Solicitor General also argued for them, then came the real response from the young members of our bar, former advocates on record, current advocates on record, and all senior here or there. But the kind of impact which they made, just in telling us about the social structure, they reminded us that, look, if you allow this judgment to be reviewed, you will be setting at naught the livelihood of lakhs of Indians who depend on these licenses to drive transport vehicles of a certain order. So this function, perhaps if a huge senior, suppose there were 5,000 clients for the claimants, they could have, obviously if somebody had collected enough money, they could have put up a good senior on the other side. But this message which young advocates on record and young seniors gave to us of a whole social system underlying a legal issue was, I think, a very important circumstance in the ultimate verdict, because as we came down the steps, we realized that any effort to tinker with a judgment which had held stable force in the legal terrain for several years might cause serious hardship to common people. So in that sense, I think a very important responsibility is cast upon you as advocates on record to give vent to the voice of the nation when you argue before the courts. And it makes no difference whether you represent a small client or whether you represent the more resourced of clients or whether you represent, whatever cause that you are appearing for. Your voice is crucial in the work which judges discharge in the course of the proceedings before the court. And by you will always realize that you will find judges like me, and I dare say we are not a dying breed but a growing breed, who know advocates on record by face, by name. It's not that their face works, but it's a kind of work which you do, which works with us. Well, I began just 2 weeks back in Goa when I spoke at the seminar which was organized by Scora. And I was so delighted to learn that, at that morning, on Saturday morning in Goa, when you would expect everybody else to be enjoying on the beach, the house was full with advocates on record. And then I learned from both Vipin Nair as well as Justice Abhay Hope, who did the valedictory session, that the same audience was there in the evening on the next day. And you would expect that people would be probably enjoying the happy hour in Salute is Goa. So I could have really taken off. I had a prepared speech then, but I didn't speak from the prepared speech. Today I don't even have a prepared speech because I really didn't know what to say. Because I feel that in so many which ways my career, my life is an open book. I don't keep secrets to myself, which is one of the reasons why I'm criticized so soundly. Because when somebody opens up their life as an open page, not everybody agrees with your shaili, as they say in English, right? Everybody doesn't agree with the way you fashion your own life, but so be it. I mean, for me, it doesn't matter. I don't look at how people, I don't either receive praise or criticism with a sense of being personal. I feel that it's my duty as a judge to put everything about my life on an open canvas, because people must know what underlies the decision-making process. That's how my life is fashioned. But significantly, what I want to share with you this evening is that over the last 8.5 years, each of you has been truly, truly responsible for my own evolution as a judge. Your insights of your cases, your arguments, small, not so small, large, have shaped the outcomes of cases. I can see faces in the hall today who have changed us in a rejoinder, when you felt that, well, the respondents were absolutely dead right. And then a young advocate on record got up and rejoined her. And you just felt I was so completely wrong. The balance of justice lies with this side. That can also be called, as we used to call as members of the bar, of Bengal ki thali, that is who change between the petitioner and the respondent and the petitioner again. I don't really know whether I was a Bengal ki thali in that sense, but I certainly know that in my court, that the person who shouted the most didn't necessarily get the best order, nor the person who spoke the last. Because people who shout the most sometimes, prey on the mental calm of the judge. And there's a wrong perception that orders are obtained by those who are aggressive, who shout, who try and bully the judge. It doesn't work like that. Because there is a great element of discretion which a judge has, not in converting the right into wrong or the wrong into right. Because when there is a wrong, you have to say it's wrong. When it's right, you have to say right. But the real issue arises in those gray areas when everybody is searching for the truth and everybody is searching for where the truth really lies. Because so often, the most difficult cases are not cases between a conflict of right and wrong or polar opposites. The most difficult cases are cases where there's a conflict of right and right or wrong and wrong. And when there's a conflict between right and wrong, that's when the craftsmanship of the judge comes up, and that's when the human element comes up. So far from advocates on record who are more, I wouldn't say docile, because the art of advocacy is not in being fair, but in being persistent, but persistent with a degree of civility. I always find when recommendations of the collegium come up before us that judges in the High Court, if we especially interact with them, say that some person is very fair when they appear for the government. Reading between the lines, when the judges say that somebody is very fair appearing for the government, means that the judges are very happy that they are conceding every point. That is not the hallmark of a good advocate. The hallmark of a good advocate is to tell the judge that this is where the balance of justice lies, this is the correct position in law, and not in that sense being subservient to the judge. But you need not be subservient to the judge while at the same time being civil with the judge. And civility is unfortunately a dying art. But for those of you who still pride yourselves for being civil in court, let me assure you that you are walking the right path. Too often you find that the temptations to cut corners in a court are so many, because you always wonder that maybe I'll lose a brief if I don't yield to temptation, if I'm fair to the court. But at some point of time, the law, destiny, whatever you call it, tends to catch up if you're easy with the truth. And so many of you who have appeared before me, I'm very happy to note, have not been easy with the truth. And because you've not been easy with the truth, that reputation grows over a period of time. So I would really not take much time, but end by first and foremost thanking you for the tremendous support which you gave me through the years, which is evidenced by this large number of people, so many of you who have come here and are standing in the ranks here just to hear me speak. So thank you first and foremost for giving me all your support. Second, I must thank you for your patience, because I can't pride myself on knowing every branch of law. when I came to the Supreme Court, I had no real experience in deciding criminal cases. Because in Mumbai, we were also specialized. And so also in Allahabad, I was the Chief Justice, so I could pick up what I wanted to do. As the Chief Justice always has that prerogative. It was when I came here that I, for the first time, learned how to do a criminal appeal. I sat with Justice Lalit and I sat with him for a good number of months, and I told him that I'm just going to observe you, analyze evidence in a criminal appeal, understand how the nitty-gritty of a case has to be unraveled in a criminal court. And I learned such a great amount from his own perseverance and perspicacity about criminal work. So I must thank you for your patience in bearing with me at a time when I was still trying to learn the ropes. Because the great difference between High Court advocacy and the Supreme Court is that in the High Courts, we take up an assignment and you work on that assignment. So when you work on that assignment for say 6 months, you've worked on tax, you're doing only tax. You're doing bails, you're doing only bails. In the Supreme Court, you are switching from consumer protection to service to bails to maybe a PIL. There is no one line of work that you are doing. And therefore, that requires a great deal of versatility on the part of the judge. Our colleagues from the bar have that versatility, which we don't necessarily have coming from the High Court. So we pick up the rhythm of the work as we come to the Supreme Court. So second, I want to thank you for having shown great patience with me during the time that I was evolving with the Supreme Court. Third, whether or not you got a favorable order, nobody questioned my motive, which was, I think, a sense of great faith that I had in all of you. And finally, I want to say that I hope that a lot of you will go from strength to strength. Many of you will become judges of the High Court. I think it's very important that the advocates on record from the Supreme Court who come from different parts of the country must fan out to different parts of the country and accept the offer of judgeship or pursue that alternative as a career option in due course. Because there's something about Supreme Court advocacy which marks you out from High Court advocacy. The High Court bars are a little, they're a little careful about accepting lawyers from the Supreme Court as judges of the High Court. There's one thing that the Supreme Court bar has, and that is the ability to look at law from a national perspective. When I was a lawyer in the High Court, I always looked at law from the perspective of my own state. I learned to look at law from a national perspective when I became a judge here. And I realized that the same applies to members of the Supreme Court. Because by virtue of the fact that you pick up that odd brief from Karnataka, from Kerala, from West Bengal, from Tamil Nadu, from Maharashtra, you realize the interrelationship of the law as it cuts across different regions, different states, different cultures. That makes for a more well-rounded judge. So I conclude by wishing you all the best. Thank you for this beautiful evening that you have given. Thank you, sir.